Let's listen in live.
Good morning, Your Honor. Karen McDonald on behalf of the people.
Thank you, Judge. Mark Keese on behalf of the people.
Good morning, Your Honor. I'm Shannon Smith on behalf of Jennifer Crumbley. For the purpose of exam and today, I am going to represent Ms. Crumbley, and my partner is going to represent Mr. Crumbley so that we can keep our arguments clean and separate.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbley.
So just for clarification, in terms of any cross-examination and direct examination, Ms. Smith, you will be taking cross-examination and direct examination for Ms. Crumbley only, and Ms. Lehman will be doing it for Mr. Crumbley.
That's correct, Your Honor.
Okay.
Judge, if I may, just regarding that aspect, we have discussed potential conflicts every hearing. I do believe that is appropriate for defendants, as well as defense counsel, to acknowledge a potential conflict and place that waiver on the record if there is one.
I have made the record of that at each appearance, and I'm planning on doing it today as well. Again, as both of you have been aware, and I've made both of you aware of the fact there's potential for a conflict of interest in this case due to the fact that your attorneys are representing you, and they are attorneys and counsel in the same firm. Ms. Crumbley, do you understand any potential conflict that might exist with both of these attorneys representing both you and your husband?
Yes.
And Mr. Crumbley?
Yes.
Ms. Crumbley, knowing that potential conflict, are you willing to waive any conflict that may exist and proceed today with Ms. Smith representing you here for purposes of the preliminary examination?
Yes.
Mr. Crumbley, what about you? Are you willing to waive any potential conflicts that exist with having Ms. Lehman representing you, knowing that Ms. Smith is representing your wife?
Yes. Yes.
All right, before we move forward, we've got a couple of motions that were filed. For the record, today is the date and time set for the preliminary examination in this case. The attorneys have had the opportunity to meet with each other regarding some of the exhibits. Is there still the necessity to address that motion?
The motion to adjourn, Your Honor?
The motion to adjourn and the basis for the reason for the adjournment.
Yes, there is. And Ms. Lehman is going to argue that motion.
Good morning, Your Honor. The defense did file a motion for a more compressed witness list and to adjourn. We have reviewed the discovery that we received from the prosecution at the time. Your Honor, may I remove my mask?
You can take it as long as everybody's comfortable with it.
Thank you, Your Honor. At the time of filing our motion, there were a number of materials that we had not received from the prosecution. Since filing the motion, the prosecution has elected to provide additional discovery to us on February 1st, February 2nd, February 3rd, and February 4th. We did again ask the prosecution to provide us with a more specific witness list. The original witness list that was provided was approximately 30 witnesses. We asked for a shorter witness list. The prosecution provided us with a list of 16 witnesses. We did ask them for more specifics regarding their witnesses so that we could better focus our attention on preparing with our clients and also preparing ourselves for the preliminary examination today. In reviewing the materials that were provided on February, I believe, 2nd and February 4th, we learned that there were some materials that had not been provided by the prosecution to us, specifically regarding one of the witnesses that they expect to take the longest today, and that's Detective Wobrowski. We have met with the prosecution. The prosecution indicates that it sounds that they do have the materials that have not been provided to us, but they have not provided them. Your Honor, we have not been able to review their report specifically created by the detective, video specifically created by the detective. It's our understanding that those reports may or may not be used today, but that doesn't mean that they don't contain information that could be relevant to the defense. And Your Honor, in the amount of discovery that has been provided to us by the prosecution so far, there are at least 67 hours of recordings. As we've made the court aware, in order to have in-person visits with our clients, we have to obtain a court order for each visit. We have to obtain a negative PCR COVID test at least 72 hours before the visit, or I'm sorry, no more than 72 hours before the visit. And we have to schedule the in-person visit with our clients. We were able to successfully schedule 2 visits with our clients last week. However, we have not been able to review all of the recorded discovery, even all of the recorded discovery specific to some of the witnesses today, because there were other materials and matters that we needed to discuss. If we do want to visit with our clients, Your Honor, as I'm sure the court is aware, if we don't do it in person, it's done through a software, which quite frankly, Your Honor, has failed us more times than it hasn't. And we're also limited in time on those visits. We're limited to half an hour at a time, and we can't schedule multiple visits back to back. So, Your Honor, it's obviously been very difficult to prepare for this examination with the amount of discovery that the prosecution has provided. And the amount that the prosecution has provided that's relevant to our clients is also varied within the amount of discovery that they've provided to us. So, Your Honor, even though we've taken a number of steps to effectively prepare for our preliminary exam today, we do still have concerns that there are things that we are missing. We just had a conversation about text messages that we haven't seen, Your Honor. So the prosecution has indicated that they may have an explanation for why we haven't seen them, but we do still have concerns, Judge. And today even, the prosecution indicated that their list is even shorter than the 16 that they provided to us as recently as last Friday. So, Judge, the police reports that we've reviewed indicate that there are dates with which law enforcement has provided over 100 gigabytes of data to the probably over 200 gigabytes of data to the prosecutor's office, and we've received that data sometimes weeks later. So, Judge, we do have concerns about the material that's been provided to us. We do have concerns that we're missing material that will be relevant to the preliminary examination. And we can't be effective without being able to review everything, Judge. So we are asking that the court adjourn the preliminary examination for these reasons.
Response?
Thank you, Judge. We just spent 45 minutes meeting with defense counsel. Defense counsel indicated that everything in this binder that we put together for the court as well as defense has been turned over. Now, just a few minutes ago, Ms. Smith approached me and said there was a text thread that she didn't think she had or may have been deleted. Our expert in computer crimes is going to testify regarding how a user may or may not delete things and how it can be exported from the Cellbrite system. That's not new information, Judge. We have turned over everything in an unprecedented fashion. By way of example,
All right, everybody, it does appear that they are having some issues with the feed coming from inside that courtroom in Rochester, Michigan, and it does look like we just got it right back. So let's continue to listen in live, raw, and unfiltered.
we are following the rules, we're following court rules, we're following all rules of discovery. We are ready to proceed today. The information that counsel just referenced regarding Detective Argowski, that's something called call detail records. We've already indicated we're not going to admit that at the exam. And those call detail records have been turned over to defense. Now, Judge, we have turned over everything that we possibly could have. We are ready to proceed today. And like I said, the prosecution has been following all those court orders.
Thank you. All right, the defendants did file an emergency motion to compel witness list or in the alternative to adjourn the preliminary examination on February 2nd, 2022. The court has had the opportunity to review the motion, the response, also did have a discussion with both attorneys relative to the nature of the discovery that had been turned over and what had not been turned over and or they believed had not been turned over. The court did allow both all attorneys to meet prior to beginning today's hearing for approximately 45 minutes to go over all that discovery. In addition, the court adjourned this preliminary examination for approximately 6 weeks because it did acknowledge and understand that the discovery in this case would most likely be voluminous. Having taken all those measures, the court finds that there's sufficient evidence that has been turned over to the defense attorneys at this point in time, that their good cause does not exist to adjourn the exam again. If there's a good likelihood that this exam will not complete today and that it may need to go into another date and time. So having taken all those factors into consideration, the court is going to deny the motion. The prosecutor also had a motion.
Thank you, Judge. The people filed a motion as well as to restrict communications between the defendants during court. It became known to us that during certain Zoom breakout sessions, the defendants were making certain gestures to each other. We're asking this court, through this court's inherent authority, to restrict the communication, Judge. I did file a plea, and I believe it speaks for itself. I do not believe there's an objection to the defense.
Response?
Your Honor, the fact that the prosecution wasn't even aware of the communications until they were later told by other people shows that our clients weren't trying to do anything to disrupt court. All of the communication, they didn't realize it was being broadcasted. They certainly didn't intend to hurt any of the victims from Oxford. On that, we apologize to the court. I already told the prosecution I would tell our clients not to have communications at the table or send messages of I love you at the table. They agreed. There was no reason to file a motion. Our clients will behave. They're not going to do anything like that, and they certainly don't mean to offend anyone.
Thank you. The court has had the opportunity to review and consider the motion that was filed by the prosecutor as well as the oral arguments. I'm going to grant the motion as it relates to in-court proceedings. Mr. and Mrs. Crumbley, this is a court proceeding. During the course of any breaks or while maybe I'm looking away or somebody else is looking away, you're not to have communication with each other. It's disruptive and it is disrespectful, okay?